Welcome everyone to today's webinar, COVID-19 Employment Update, presented by Barclay Damon. Many thanks to our presenters, Michael Schiatti and Brianna Cristiano, for being with us today and all the participants who have joined in. We'd also like to thank our educational series sponsor, Chemung Canal Trust Company. Please note this webinar is being recorded to share what we learn with the business community. Michael and Brianna will share their presentation with you, then follow with time for questions and discussion. Please use the chat to submit any questions during the presentation, and just a reminder when others are speaking to please keep your audio on mute to minimize background noise. With that said, I'll turn things over to Mike to start things off.
Awesome. Okay. All right, so good morning, everyone. I'm Michael Schiatti. I'm one of your presenters. I'm going to lead it off. Brianna and myself will go back and forth a couple times. You know, we prepared these slides several weeks ago, and even since then, we have some other updates to give you in this ever-changing world here of COVID-19. So, just see here. I am losing just. I don't have the slide. The slides are. Let me just see here. It's too big at my end. I can't see it. Is there something you're doing at your end that's causing that? Let me just.
I can.
All right. I just reduced. I reduced the size.
Okay.
All right. So that should work now. Let me just see. Sorry, everyone. It's a brave new world. We do all these webinars remote now, and then the only thing that gets in our way is technology. Okay. So. Myself and Brianna's contact information is in here. You know, we'll do Q&A at the end, and you can ask questions throughout. You know, if you forget something and you want to ask us a general question in a day or so, that's fine. Go ahead and email us, and we'll get back to you as quick as we can. I am on Twitter and LinkedIn. LinkedIn, I will let you into the network on one condition. You just promise not to sell me anything. And then Twitter, you're free to follow me. We post daily updates, not only on COVID, but other labor and employment and legal updates as well. So our agenda that we initially prepared was to first give you a quick update on the Family First Coronavirus Response Act. That information is slightly outdated, but I'll be able to give you the new information in that regard. We're going to do a general recap of where we are in the New York State COVID-19 sick leave law, general review and update. There is some additional guidance, both for healthcare workers and what I call everyone else. And then we have the COVID-19 vaccine issues, which we're going to go through. A couple things that did not make it into the presentation, which you need to be aware about. Effective March 12, and expiring on December 31, 2022. So again, March 12, 2021 through December 31, 2022. There is a provision that has just been added to the labor law and the New York State Civil Service law, which allows employees to take 4 hours off to go get the COVID-19 vaccine. That's it. It's not for side effects. It's up to 4 hours to go get the vaccine. You can agree otherwise if you have the pleasure of having a union and you incorporate it into the collective bargaining agreement. There is a anti-retaliation provision which they have placed in there as well. But please realize, so if your employee insists, I have to go get the COVID vaccine Monday at 8 a.m. And I have to go to Syracuse to get it. You know, you have 4 of those hours will be paid under the COVID-19 vaccine leave law. And then the rest is probably going to be, I mean, if they need more than 4, they're going to be able to take it under paid sick leave. So just keep that in mind. new law just signed by the governor on March 12th. The other thing that we have had in the last couple of weeks is the American Rescue Plan Act of 2021. It is packed full of stuff. New COBRA rules are under there, and if you're interested in the new COBRA rules, we can send you a quick legal alert that we prepared, and our benefits people stand ready to help. There are massive changes to COBRA. On the unemployment front, there's an unemployment insurance extension. They extended enhanced unemployment insurance through September 6th of 2021, including the extra $300 federal pandemic unemployment comp. It was also extended for independent contractors, the self-employed, and the gig workers. The law extended the pandemic emergency unemployment compensation for those who exhaust state benefits to 53 weeks, up from 24. There is unemployment insurance tax relief for those individuals who receive unemployment up to $10,200 will be non-taxable to the individuals if they have adjusted gross income of 150,000. I'm sorry, less than 150,000. In a second, we'll go through the Family First Coronavirus Response Act. The slides will say that the tax credits were extended through the end of March this year. When we prepared it, that was accurate. They are now extended through the end of September of this year. So if someone wants to take Family First Coronavirus Response Act leave, and you are covered and they qualify for the leave, which we'll go through in a second, you can pay them under the law and take the tax credit through the end of September of this year. Now, please remember, because we're in the great state of New York, we're going to be going over the New York State COVID-19 Leave Act in a second. You always have, if the employee qualifies under both laws, you have to grant the employee the greater benefit, whichever one puts more money in their pocket, the federal or the state. It's not necessarily the federal. In most cases it is, but not in all. And please keep that in mind. If you pay an employee under this New York State COVID-19 Sick Leave Act, there are no tax credits. It's only if you pay under Families First. So that's just a quick update of things that have changed since we prepared this. And there's so much more that I'm sure will change as we go through this. We've also given you some attachments. When we get to the vaccine issue, you're going to have employees objecting to taking the vaccine. I have a disability. This is my disability. I can't take the vaccine. Here's the doctor's note. You're going to have individuals who are female, of childbearing years. They will object because they may take the position it is unproven in this regard, and the tests and the studies are still out. Although it's starting to develop now. I saw a study the other day that it appears that if, at least with one of the vaccines, if a female is pregnant, they get the vaccine, the antibodies are passed on to the child. And again, I'm not a scientist, but I read that and I found that to be interesting. The other thing you're going to see are individuals objecting to a certain vaccine. I think it's the Johnson & Johnson vaccine that has been made with stem cells from aborted fetuses. They will object on religious grounds, saying, I don't want that particular vaccine, and you'll have to handle religious accommodation issues. So we're going to talk about disability-based accommodations, religious-based accommodations here today. We've given you a sample New York State reasonable accommodation policy and the actual regulations that you have to follow for disability accommodations. don't just blindly adopt that policy. I gave it to you as an example. There are things in there I like, there are things in there I don't like. The things in the policy I don't like is, hey, this is how you file a claim with the New York State Division of Human Rights. Don't ever give your employees more information than you need to, but this is a good guide in that regard. On January 20th, the New York State Department of Labor issued new guidance on COVID-19 sick leave law for what I call the general industries. That is at Appendix 2. Appendix 3 is the combined Department of Health and Department of Labor guidance for individuals who are in healthcare and COVID-19. Generally speaking, you're going to see you can get the COVID-19 sick leave up to 3 times in certain cases at the end of the day. Appendix 4 is a New York State Department of Health COVID-19 immunization screening form. For those of you that have already gotten the vaccine, you know, there was no form, you know, when I went and got it, I didn't have to sign anything and fill out anything. They asked me a couple screening questions. The screening questions do not match what is on Appendix 4. I also think it depends on which vaccine you're getting, where you're going, how busy they are, and what have you. But those will sort of tie in Appendix 4. In Appendix 5, we're really not going to discuss here, but if you're covered by OPWDD, there is some new return to work guidance that was issued in early February, which we just wanted you aware of. If you're not covered by it, don't bother reading it. So first, the Family First Coronavirus Response Act update. The leave provisions expired on December 31 at the end of last year. You as an employer, if you're covered by the law, can voluntarily continue those, but you have to do it for everybody or nobody. You can't pick and choose the individuals you're going to give this to. It's everybody or nobody. The benefit to you doing it is, again, the tax credit, that you would pay the employees under this law and get a tax credit for what you had to pay the employee. Couple caveats. You know, we had many seminars, webinars we did early last year on Family First Coronavirus. I just gave you a little recap in summary here. There's the expanded FEMLA and the emergency paid sick leave. We're not going to go into that in detail. You can't grant more leave than the employee is entitled to, number one, and the employee must qualify for the leave. So under the regulations, they had to have qualified. You just can't take the position, oh, the employee asked for Family First Coronavirus leave, we're giving it to them. You need to run the analysis. You need to make sure you have it, because remember, you're going to be certifying to the Internal Revenue Service under penalties of perjury that these tax credits that you are requesting are legitimate, and you are at risk for an audit by the Internal Revenue Service. And if they audit you and you cannot prove that Johnny was entitled to Family First Coronavirus leave, you might get dinged in that regard. So be very careful. And we put some other information about it. The key is they have to be eligible for the leave. I can't stress that enough. And if they are, remember, there's a second analysis you need to do. You need to determine whether they're better off under New York State COVID-19 or the federal Family First if you have voluntarily decided to extend it. And some companies are not. Some companies have taken the position, nope, time to get back to work. And there's nothing wrong with that in that regard. And then you only have to deal with the New York State COVID-19. Another benefit to granting leave under Families First after January 1 of this year is the Department of Labor is not going to take complaints or investigate any employer relative to Family First Coronavirus leave that occurs after January 1. I got it right from the horse's mouth. Why? The leave provisions have expired, and the U.S. Department of Labor Wage and Hour will not be investigating and will not be enforcing. Okay, so that's where we are. You know, we gave you a quick, dirty summary of the America Rescue Plan Act of 2021, quick summary of where we are with the Family First Coronavirus Response Act tax credits, and we mentioned to you the new New York State COVID-19 vaccine law in that regard. You know, the next thing, get ready. I think they've got a deal on recreational pot. So I think that's the next best thing that's coming that we're going to have to deal with. So the first thing we're going to do is a quick overview of the New York State COVID-19 sick leave law. It's not as in-depth as the one we did last year for this organization. It's just sort of an overview where we are, how it's morphed over the last year. One of the things I want you to remember, this is a permanent law. This law is not going anywhere. When COVID is over with, this law remains. So unless they take it off the books, this, unlike Family First Coronavirus Response Act, is a permanent law that you as an employer will have to manage going in to the future. Some areas we're going to cover, we're going to talk some general background. We're going to talk about covered employees and covered employers. And then we're going to talk about the COVID-19 sick leave benefit trigger, COVID-19 sick leave benefits, what you're entitled to as an employee, the job restoration rule, and then the interaction with the New York State paid sick and safe leave law in that regard. In the last year, they've thrown a lot at us, you know, it's okay to feel overwhelmed. I think everyone at times during COVID on these leave laws had to take a breath. I mean, the key is we need to grant the employee the greatest benefit possible. Sometimes that takes a while to figure out. You know, an employer gives us all the information. I'll get back to you in an hour and we'll figure it out. We'll go through the regs. So don't think these are quick answers. I don't think they are, as a matter of fact. So let's do some general background. You know, the initial COVID-19 sick leave law was passed back on March 18th of last year. It's been around for a year now. It was signed into law that day by Governor Cuomo and did have some retroactive effect to those that were already in a quarantine. You know, the key on any inquiry here is who's a covered employer, who's a covered employee. The law did not define who an employee was. On its face, it applies to everyone, full-time, part-time, per diem, etc. What we have seen, and some of the things Brianna will go over, is that the Department of Labor carved out one set of rules for what I call the general industry and another set of rules for healthcare employees. You know, some of that guidance is questionable in my opinion. Is it legal? Is it not legal? Did the state overextend their authority? Unless you're willing to challenge it and to pay for the legal challenge, the answer is it is legal and follow it. If you want to potentially challenge it, you know, that is a possibility, but it's going to cost you a lot of money, and I'm not sure there's a lot, quote, at stake to review it. So just remember, all employees are covered. The law will only be available to employees who have been officially or formally quarantined or isolated by the state or local governments. And as you've seen in the guidance, that has morphed over time what that means. Sometimes it's simple as the doctor says you're on quarantine. Initially, you had to get the quarantine order, but the guidance has loosened that a little bit as we've gone on. A covered employee does not include the following, and we have seen all these categories. Employees who are voluntarily quarantining or in isolations, no healthcare provider, they're self-diagnosing and they're saying, I'm not coming out of my house. If they don't come to work, you can discipline them. Employees who fear they have been infected with the virus and don't want to come out. They have no realistic belief other than that what they think. Again, that the law does not cover them. They don't come to work, you can discipline them. Employees who object to reporting to work for fear of exposure. Now, this has changed over time. You know, some of you have brought your workforce back. Some of you are allowing it to be remote. We'd have to analyze essential, non-essential business. And, as we all know, the rules have changed over the last year. Employees who were terminated already placed in a layoff status, they are not covered. The law does not apply to individuals who have been quarantined or isolated, are asymptomatic, not yet diagnosed, and are physically able to work. Please note, that could change on a dime. The next day someone has, a symptom. The next day they have a diagnosis, and then they suddenly become a covered employee. There was, the law does not contemplate any benefits for employee who are home caring for children due to a mandatory school closure as a result of the pandemic. Now, the devils are in the details here. We've gotten through most of that. It wasn't really as clear in the beginning as it is now, but I think we've gotten through the confusion in that regard as to, with the interaction with the Paid Family Leave Act. And some of you didn't have to worry about that because of the size of your organization. It was simply too big. The stupid employee defense that some of you have heard me talk about, initially you can't get benefits if you voluntarily take a travel to a level 2 or 3 country as designated by the CDC. So, early on, people were still going on vacation. Remember how hard Italy was hit. They were diagnosed, they were designated as a level 2 country, is my recollection. People were still finding ways to get to Italy before they closed down everything. And they were getting infected and they wanted benefits. No, if you went there and you knew it was a level 2 or 3 country, you're not entitled to benefits. Okay. The defense does not apply if the travel was taken as part of the employee's employment, the employer directed them to go, the employee had notice of the CDC warnings, and they would not have been otherwise ineligible for benefits. If you had someone fall into this, and this is probably going back a bit now, you had to still let them use their PTO accruals. There is a mention now in CDC guidance of level 4 countries. The law was not amended to include level 4 designated CDC countries. The law on its face applies to all employers. Depending on the size, how many employees you have, it will dictate the benefits, but it clearly applies to public, private, for-profit, and not-for-profit. So with that, I'm going to give up the remote control, Brianna, and you can grab it.
Good morning, everybody. Thank you, Mike. I think I have control. So I'm going to start off by talking about what the benefit triggers are under this law. So on the new law, the benefits are triggered for an employee who's under a mandatory or precautionary order of quarantine or isolation, which is issued by the state, the Department of Health, any local board of health or government entity that can make such orders. In addition to that, we have some counties and local government agencies that have issued their own orders of quarantine covering individuals who've been tested and who are awaiting results or who have already tested positive. So here is a list of the counties that we're aware of right now that have their own separate orders. And so when you're analyzing whether or not leave is appropriate, those county orders have to be looked at in addition to any New York State law. In addition to that, there's a couple counties that have their own isolation and confinement orders. Washington County is an example of one that has their own order. And there was a regulation regarding isolation in the event of treatment or exposure to COVID-19. This has since been repealed in May of last year, so this is no longer in effect. Now, as Mike talked about earlier, we do have some guidance which specifically relates to healthcare employees. You can see that the definition of healthcare employee under this guidance is very, very broad. Any person employed by a doctor's office, hospital, long-term care facility, outpatient clinic, nursing home, and it goes on from there, including educational institutions offering healthcare instructions and so on. Now, under this law, any employee that falls under the definition that we just looked at, who following a period of quarantine or isolation is still receiving a positive COVID-19 test after they return to work, must stop returning to work, and they're going to be deemed, they are entitled to benefits under this law, even if they had already received a previous leave under a prior order of quarantine. And so in these instances where they receive a positive test, they're required to submit to the employer this documentation of the positive test, because the positive test is what entitles you to subsequent periods of leave after the healthcare employee's already been under a previous order. So you have to submit documentation of leave unless it was the employer who gave the employee the test that yielded the positive result. And so there's another separate provision which says that a healthcare employee who is subject still to an order of quarantine or isolation and continues to test positive as that ends must also not return to work and will be subject to a second mandatory order of isolation. And so the same as the previous provision, the employee is required to submit the documentation of the positive COVID-19 test unless it's the employer who administered the positive test in the first place. So we know that the periods of leave are not endless for healthcare employees. They are able to get COVID leave for 3 orders of quarantine or isolation. And as we just discussed, those 2 subsequent tests of periods of leave after the first one are given when there's a positive COVID-19 result. Okay, so let's talk about what the benefits are under this law. So employee counts in the law are as of January 1st, 2020. This seems odd now that over a year has gone by since then, but we don't have any guidance that suggests anything different. And so for purposes of figuring out how much leave the employer is entitled or must give the employee, we're still counting as of January 1st, 2020. So for a business with 10 or fewer employees and with a net worth of less than $1 million in 2019, the employee is entitled to guaranteed job protection, paid family leave and disability benefits through the employer's policy, and their salary for the duration of the quarantine. For an employee who works for a business with 10 or fewer employees, but with a net income greater than $1 million in 2019, the employee is then entitled to 5 paid sick leave days during the quarantine order. And then we'll also still get, after these paid sick leave, the paid family leave and disability benefits through the employer's policy, as well as their salary. So the same provision or the same amount of leave applies to employers with 11 to 99 employees. So you get the 5 days of paid sick leave. And then after those paid sick leave days have lapsed, the employee is eligible for paid family leave and disability benefits through the policy, as well as their salary for the duration of the mandatory precautionary quarantine. So for the largest employers, which are 100 plus employees, the employee gets guaranteed job protection, 14 days of paid sick leave, and this applies as well to public employers. So public employees get at least 14 days of paid sick leave. And the law has clarified for us that public employees of towns, public schools, public colleges and universities, counties, cities, village, fire districts in the state of New York will get the benefit of the 14 paid sick days. Now, something interesting to note is that the number of paid days is calendar days. And so the only amount that's going to be owed to the employee is the number of days they would have worked within either the 5 or 14-day period. We also know that paid leave payments are still going to be subject to the pay requirements of the labor law, and so leave payments should be made in the paycheck for the applicable pay period of that leave. Okay, so is there a waiting period before an employee receives paid family leave or disability benefits or quarantine leave benefits? No, there's no waiting period for benefits as a result of the mandatory or precautionary order of quarantine or isolation. We also know that employees are not obligated to pay back any benefits received during the COVID-19 quarantine leave. We also know that employees are not required to use any accruals, and employers are not permitted to charge an employee's existing balance of accruals of any paid time off when they should be able to use COVID-19 leave instead. So employers are not permitted to charge an employee in any way to their paid sick leave when they were entitled to COVID-19 leave. Okay, Mike mentioned this briefly earlier, but this leave law was made available to employees retroactively, just briefly though. It applied as well to any employees who, when the law was enacted back in March of 2020, were already under an order at that time. So it was applied to them as well. Okay, there is a job restoration rule in this law. As we discussed earlier, is the employee's job protected during COVID-19 quarantine leave? Yes, the job is protected during the leave, and the employee is entitled to be restored to the position that they held before taking the COVID-19 leave. So we also know that an employee cannot be fired because they took this leave. Now, this doesn't necessarily mean that the employee can't be terminated for any other appropriate reason, but we would encourage that any termination that occurs around the time of this leave is carefully documented for the reasons why the employee was terminated, and the reasons why cannot obviously be for them having taken COVID-19 leave. So an employer should not count any absence toward the employee for taking COVID-19 leave, and they also should not count the absence in a way that could lead to discipline, discharge, demotion, suspension, or any other adverse action. So with that, I'm going to turn it back over to Mike.
Okay. So, just to follow up on Brianna's comment, what's an example of when I could fire them? They take COVID-19 sick leave. You go through their desk and you discover pornography. You discover a stash of marijuana. You discover a bottle of Jack Daniels. And I'd still confront them when they got back, but you're going to be able to take action on it if it violated the policy. Another thing would be if there's a workforce reduction in that regard, just make sure it's not a workforce reduction of one, because that usually raises some eyebrows with us. The other thing we're going to talk about briefly is the interaction of COVID-19 with the New York State paid sick leave law. We did 3 webinars already on the New York State paid sick leave and another one on the domestic violence protections. So we've already covered that pretty well for the organization. So I'm not going to spend a lot of time on it, but just remember, we do have the New York State paid sick leave here. So if something doesn't fall nicely into Families First or COVID-19, I can almost guarantee you it is going to fall into the New York State paid sick leave. If they take COVID-19 sick leave, you cannot charge their paid sick leave bank. If they take the COVID-19 vaccine leave, which is that new one I mentioned at the beginning, you can't hit their COVID-19 bank and you can't hit their paid sick leave bank. So there's a lot here you're going to have to keep track of. Some of it will be expiring and some of it won't. Paid sick leave, very similar to the COVID-19. You know, they have the leave is tied into whether it's paid or unpaid and how much you get, depending on the size in some circumstances, how much net income you make. And again, we've already gone over this recently, so I just put the slides back up here to refresh your memory. Sick leave use is not only for the employee, it's also for the employee's family member. Again, there's two buckets for the sick leave, and then there's the safe leave, which is the domestic violence. Again, I don't. The point of today is not necessarily go back over that in detail. We just wanted you to realize this is part of the equation here in that regard. So okay, so now you've sort of know what the status of Family First is. We know COVID-19 sick leave law is still around. It's a permanent law. We now have the vaccine leave law, which we have to sort of work into the equation here as well. If not covered by either of those, paid sick leave is probably there. And for some of you, depending on your side, you got to worry about paid family leave. So now we are at a different point in the pandemic than we were early on. We are at a point where individuals are being vaccinated. You know, the last number that I saw was Central New York was about 30% vaccinated the other day. And I think those numbers are going to increase. You as employers are going, some of you are going to want to know who got vaccinated and can I ask for proof? The answer is yes, you can. And yes, you can ask for proof. The card, the vaccine card, you just put it in their medical file in that regard. And actually, I think you have an obligation to do that as part of the reasonable accommodation process. I think it's an employer obligation to track the percentage of the workforce who is vaccinated because it will come into play on the reasonable accommodation issue, both for disabilities and for religion. So now we're dealing with a different set of questions. People objecting to the vaccine. I'm not getting it because I'm disabled. I'm not getting it because of religious. Not on my body. Don't touch me. No real disability reason, no real religious reason. They're just they don't want it for whatever reason. That's a too bad, so sad scenario. The EEOC is not really answering the question directly. Can I, as an employer, compel the vaccine? We're recommending you don't do that. That you strongly recommend it to individuals. That you keep track of individuals who are vaccinated, and at some point you may have to determine: am I going to exclude, not terminate, exclude individuals from the workplace who are not vaccinated? And we'll talk about that a little bit today. So the alphabet soup of employment laws are triggered here. The ADA and the New York State Human Rights Law, the Rehabilitation Act, the Genetic Information Non-Discrimination Act, which everyone seemed to have forgotten about until COVID hit. Title VII, including the Pregnancy Discrimination Act. All of these are going to come back to the forefront here. Everything that we have learned as HR professionals over the last 20, 25 years with the ADA and Title VII, that knowledge is all we have to do is take it and make it applicable to the COVID scenario. Now, one of the things I want to make crystal clear to you, if the CDC, the Department of Health says, employer, you do X, you do X. You do not worry about the employment laws. The employment laws are secondary to health and safety guidance issued by the CDC in that regard. So your first order of business is to comply with the CDC, federal, state, and local health guidance. Pure and simple, not really up for debate. The EEOC has said as much as well. Some of the things we're going to talk about here are some the ADA and vaccinations and what are the rules. the ADA in Title VII regarding mandatory vaccinations, and then I'll turn it back to Brianna, and she'll bring it home with talking about Title II of the Genetic Information Non-Discrimination Act and vaccines. It's not really the vaccine we're worried about per se, but some of the pre-screening questions, some of the other things that can come up. And notice the thrust here is if you as the employer compel the vaccine, you as the employer administer the vaccine, you as the employer contract with a third party to administer the vaccine. If you simply tell if your employee simply goes to Walgreens to get the shot, none of these concerns really come about because the employer was not dictating certain things. So that's the line I want you to sort of realize in that regard. But there's some things here like the collection of the vaccine cards, which we're going to talk about. So let's start with the ADA and the vaccination issues. You know, we have the concept of the medical exam. Is the administering of a authorized and approved COVID-19 vaccine considered a medical exam under the Americans with Disabilities Act? It is not. It is clear it typically has to be a procedure or test administered by a healthcare provider to get information about the individual's physical or mental impairments. It could be an X-ray, a CAT scan, an MRI, and some others that we've listed here. So the shot itself does not qualify as a medical exam, and we don't have to worry about the medical exam rules. Okay, you just don't get a vaccine, do you? Those of you that have gotten flu shots realize that right before the flu shot, you get the pharmacist is going to have you answer some questions. They're either going to do it verbally or in writing. Typically, it's in writing. When you go and get your COVID vaccine, I was asked a series of questions verbally, and when I got shot 1 and shot 2, the questions were different that I received. It's those inquiries that are likely to be disability-based inquiries, likely to elicit medical information. So, for example, you know, one of the questions posed to me was, "What is your underlying health condition?" That is a disability-related inquiry. "Are you sick today? And if yes, what's the matter with you? You know, and they'll ask you also about, did you have any adverse reactions to shot 1 in that regard? So some of these other questions that pop up are what we're worried about. But again, if you're not dictating it, if you're not controlling the vaccination, you as the employer aren't going to care in that regard. Why? Because it's being administered by a third party that you have no contact with in that regard. If you as the employer wish to administer the vaccine, assuming we get to that point, you're going to have to ask these pre-screening questions. There's no if, ands, or buts about it. And you're going to have to show that those questions are, quote, job-related and consistent with business necessity. Now, as long as you follow the DOH guidance, I think we put in Appendix 4, their pre-screening questions, and depending on the vaccine that you're going to be giving to your employees, you follow the manufacturer's vaccine pre-screening questions, you're going to be able to easily show it's job-related and consistent with business necessity. It's when you deviate from those questions and start asking other information, that's when your problems are going to arise. So CDC guidance, Department of Health guidance makes clear you're able to ask these pre-screening questions in that regard. The question comes up, are there exceptions to these? And the answer is going to be yes. At the end of the day, there are going to be some screening exceptions. So let me just jump ahead a little bit. If you have offered the vaccination on a voluntary basis, so we're not mandating it, but we're going to make it available to our employees. We're going to be doing it in the lunchroom or wherever it is. These pre-screening questions, the answer to the pre-screening questions must also be voluntary. Now, if the employee chooses, I'm not going to answer these pre-screening questions. Okay, no harm, no foul. You don't get the shot, because we can't medically give you the shot without knowing the answers to these questions. The corollary to that is if the employee refuses the vaccine or refuses to answer the pre-screening questions, make sure your supervisors know not to give them any crap. That is their right. There may be a price to be paid. It could be exclusion from the workplace. It might ultimately be termination of employment, no threats, no retaliation in that regard. The third one, the second exception, you are not administering it. You are not contracting with like a Walgreens to administer it. There's no contract where you're controlling it. You basically tell your employees, hey, go get the shot. And they can go anywhere they want. The pre-screening questions are fine, that are asked by the pharmacy. Why? Because they must be asked, number one, and two, you as the employer are not controlling in any manner the process. And please remember, any information that you get as a result of pre-screening questions or the vaccination card must go in the employee's medical folder. There's no ifs, ands, or buts about it. This concept is not new. It's been around for 20, 30 years. And you must have a separate and distinct medical folder for each of your employees. So again, just some general things. The vaccine shot itself is not a medical exam, is not a disability-related inquiry. The pre-screening questions will qualify as disability-related inquiries. And again, we went over the rules of when are you mandating the vaccine, or are you just telling the employee, go get the vaccine if you wish, and you're collecting the cards. Now we're going to loop in Title VII a little bit and the ADA. We're going to talk about the reasonable accommodation process itself, both for disabilities and for religious-based objections. I've already mentioned this. Asking an employee for proof of vaccination, is that a disability-related inquiry? Is that a medical exam under the ADA and the human rights law? The answer is clearly no, it is not. Just getting the proof of the vaccination and nothing more does not trigger the ADA. If they give you other stuff, like those of you that went and got your shot, and if you had an underlying health condition, you had to bring a letter. And that letter from your healthcare provider said what the underlying health condition is. When you get a copy of the card from your employee, don't take the letter, just take the copy of the card, because the information in that letter is, in fact, medical information. You just want to know if they have proof of vaccination. We're not trying to be snoopy and go into why they get it. And let's be honest, most of your employees are going to tell you anyways, and they're yapping saying, oh yeah, I was able to get it. Here's why I was able to get it. Sometimes when they come, if let's say the employee went to the pharmacy may give them some additional paperwork back. Make sure all you get is the card, not the additional paperwork that the pharmacy may have given. Where can employers and employees learn more about the COVID-19 vaccine? The COVID-19 vaccine is under an emergency use authorization. It is not under the regular vaccination process. For the foreseeable future, the vaccine is under the EUA grant, which is different than the FDA vaccine license approval. Now, the reason this is ultimately important, because you're going to have some employees objecting to the vaccine. The FDA has an obligation to ensure that the health and safety of the vaccine, and that the vaccine risks or that the benefits of the vaccine outweigh the risk. And you can explain that to employees, because you are going to have a group of employees who are simply going to refuse the vaccine. You can point them to the FDA's website in that regard. I've given you the link here. There will also be patient fact sheets on the various vaccines. They differ a little bit. So please don't be afraid to, if you have a naysayer, direct them to the site, print out information from the site, etc. Let's change the facts slightly. If an employer requires vaccinations now as they become available, how should you respond to an employee who indicates that they are unable to receive the COVID-19 vaccine because of an underlying disability or medical condition? The same way that you do if someone asks for reasonable accommodation under a disability. You run the process. It is no different in that regard. So we will run the reasonable accommodation process. A lot of these are turning out, they don't have an underlying medical condition that prevents them from getting the vaccine. They just don't want the vaccine. And guess what? That does not count at the end of the day. The ADA is going to allow you as an employer to have a qualification standard that individuals that are a requirement that an individual shall not pose a direct threat to the health and safety of individuals in the workplace. And eventually where we go here, it's a two-step process. Can I exclude individuals who do not have the vaccine from the workplace? Maybe. And then the second step is, if they have no work to do at home, can I ultimately terminate their employment? Maybe. They're two separate inquiries in that regard. If you have a health and safety qualification, such as a vaccination requirement, and the vaccination requirement screens out or tends to screen out individuals with a disability, you as the employer have the burden to show that the unvaccinated employee would pose a direct threat to a significant risk of, or substantial harm to the health or safety of individuals or others that cannot be eliminated or reduced by a reasonable accommodation. That is a employer burden at the end of the day that you're going to have to meet. We're going to have to document it, and before we exclude someone from the workplace, or the second step, terminate them, we better make sure we've got the goods to justify our position. In evaluating direct threat, we look at the duration of the risk, the nature and severity of the potential harm, the likelihood that potential harm will occur, and the eminence of potential harm. A lot of this will be driven by science and medicine and things that you and I may not be familiar with. I went to law school for a reason. I didn't like science and I didn't like math. So you have to be able to justify the direct threat. You may have to bring in a consultant in that regard, a physician, an epidemiology expert, someone to say, this is what we're going to do, here's why, and here's our medical justification for it. If you as the employer conclude that there is a direct threat, would include a determination that an individual will expose others in the workplace to the vaccine, and you determine that an individual cannot be vaccinated due to a disability, and they pose a direct threat to the workforce. Again, we're going to run the reasonable accommodation, and ultimately, we're going to have to decide, are we going to exclude this person? And then step two is, if there's no work for them to do at home, are we going to terminate? It is not an automatic termination. Step one is an exclusion from the workplace. Step two is a termination. The reason for that is, there is something you can do in between. We're going to exclude them from the workplace. We have no work for them to do at home. So what would be a reasonable accommodation? Give them 3 months off without pay and let's see where the science is. Let's see where the vaccination is at that point. Maybe in 3 months, the answer will be different in that regard. And they're going to be getting, decent money at least through the end of September on unemployment. So keep that in mind, that we may give some additional unpaid leave. They're probably going to qualify for unemployment. Before you can decide to terminate them, you have to consult with all other applicable labor and employment laws. You have to grant the employee the greatest benefit under any of those laws. The one that's been coming to mind for us is this unpaid leave, as the science on the COVID-19 vaccine develops in that regard. COVID has proven that we can work at home. I think most people can work at home, not everyone. What if I have to supervise 10 people and those 10 people are in the office, but the supervisor is not? I'm not sure that's going to fly in that regard. So we have to evaluate it. We look at the other laws and we come up with, with a reasonable, can they work at home? Yes, or no. The accommodation process, please make sure your managers and supervisors know about it. Make sure they communicate it to the employees. Remember, your employees do not have to come out and ask, I want a reasonable accommodation. They have to say enough so that the supervisor realizes it. Yes, take out your crystal ball in that regard. If the supervisor has any doubt whatsoever, they go to HR or whoever is running the accommodation process. I want the accommodation process centralized. I want HR running it so everyone knows, everyone's on the same page. These are individual requirements. I do not want a supervisor running a reasonable accommodation. We just had a case where it was clear the supervisor signed off on the policy, basically said, dear supervisor, if you find out an employee needs a reasonable accommodation, you are not to run the accommodation request. Rather, you are to give it to HR. This supervisor chose to ignore it, ran the accommodation process and denied the accommodation. HR knew nothing about it. We got sued, and when we're developing our response, then and only then does the supervisor tell us, oh, I talked to her about accommodations and I denied it. It caused a big problem. Make sure your organization knows what the accommodation process is supposed to be, centralize them, bring them to HR, and that's where I think you want to run this. Remember, you have an obligation as an employer to engage in this interactive process to identify workplace options that do not constitute undue hardship. Undue hardship is the ultimate defense here. You do not have to grant a reasonable accommodation if it causes undue hardship. And it's a tough standard to meet, but you might be able to meet it. The interactive process includes determining whether it is necessary to obtain supporting supporting documentation about the employee's disability. So let's say the employee comes into you and says, I have a heart condition, I can't get the COVID shot. Can we tell by looking at the employee that they have a heart condition? No, because they put their medical in dispute. You are free to ask for medical information, but you are not required to. You can accept them on their word. I take the position, trust but verify, just to discourage the liars amongst the workforce who would lie about a disability. If they don't cough up the information about the medical condition, you can automatically deny the accommodation request. You also have to consider possible options for accommodations, given the nature of the workforce and the employee's position. Can we put them in another position? Can we send them home? Can they work a reduced leave schedule at home? Things like this are all part of the accommodation process. You also, remember I told you I want you to track who has the vaccine? Here's why. How many people have been vaccinated is part of the equation to assess undue hardship. if your workforce is 99% vaccinated, all right, the risk of allowing an individual who has not been vaccinated into the workforce is really, really low. Whereas if 10% of your workforce has been vaccinated, I think that's different at the end of the day. So we're advising to keep track of individuals who have been vaccinated. And again, remember it goes into the medical file. Those of you that have heard us speak before on accommodations, remember we've referenced the Job Accommodation Network. Just Google it, Job Accommodation Network. They have prepared a link on COVID-19 reasonable accommodations. I've given you the link here. It will go right to their webpage, and you'll be able to explore reasonable accommodations. As an aside, any medical condition that an employee has and you can learn about the reasonable accommodations on this website. It is a government sponsored website. It's awesome. Let me just be frank. I trained we sit in the Northern District of New York, the judges' law clerks. I trained the judges' law clerks, like, I don't even remember, 10 years ago on the Job Accommodation Network. They didn't even know it existed. And now they sort of look to it for guidance on reasonable accommodations and things like that. You can also rely on CDC and Department of Health guidance to determine whether accommodations would pose an undue hardship. So if the CDC says, hey, you can't do this, well, obviously it's not allowed and it's going to pose an undue hardship. Please remember that all requests for reasonable accommodations are based on individual determinations based on the particular job duties the employee does. I also take a look at OSHA guidance. I've given you a link to the latest OSHA guidance. You know, OSHA was all excited when they sent this out a few weeks ago. I read it, and I think they just rebranded some stuff. I didn't think there was anything new and exciting here, but I think it had more to do with the change of administration and politics than anything else. But you can take a look at the OSHA link here. I think most of it at this point is common sense for us. Remind your managers, if Jane wants a reasonable accommodation, he can't go around telling people what Jane's medical condition is. He can't go around telling people that she's requested an accommodation. He has an obligation to keep it to himself and discuss it only with supervisors that have a need to know. Also, they need to realize there can be no retaliation in that regard. Okay, so let's talk about religious. Now, the accommodation process is interactive, it's individualized, it's the same rules for religion. Religion accommodations are dictated by Title VII and the New York State Human Rights Law, and not the Americans with Disabilities Act. If an employer requires vaccines when they're available, how should it respond to an individual who indicates, I'm not taking the vaccine because I have a sincerely held religious belief or practice? Now, I gave you the example where this could come up, where one of the vaccines was developed using stem cells from aborted fetuses. You could have someone object on religious grounds to that particular vaccination. Okay, what is a simple, reasonable accommodation? Okay, we're not going to make you take that vaccine, and assuming you're dictating it, go get the Pfizer shot. Do you have a religious objection to that? That's a reasonable accommodation. Once you're on notice, you have this obligation to discuss the issue with them, and then you have an undue hardship defense, just like you do under the ADA. I don't think Title VII says the courts define undue hardship as having more than a de minimis cost. Not really helpful to me. In a second, I'm going to walk you through the New York State Human Rights Law factors, which are very helpful, very clear on how you determine what is a reasonable religious accommodation here in New York. The EEOC guidance, religion, it is very, very broad. I want you to realize that. You're going to get some potentially odd requests. You will potentially be learning about some, what I would call, don't take offense, anyone on this call, odd religions outside the mainstream. That's all I mean. What is a mainstream religion? Christianity, Islam, Judaism. Those are mainstream religions. I don't think anyone's going to argue with me in that regard. And if you do, don't mean to offend you. That's just my opinion. How about this religion? The Church of Pasta, spaghetti, Pastafarianism. It's a real religion. Jediism. They have over 250,000 followers. It is a recognized religion. Yeah, Star Wars. How about the Church of First Cannabis, the pot smokers? Another recognized religion. You're going to deal with some potentially fringe religions. Vampirism is a recognized religion. Don't laugh, don't chuckle, don't tell them, oh, you can't be for real. We have to analyze it. You may have to do some research on the religion themselves. The other thing, they don't have to actually be a member of a religion. So I tried a case once where the individual thought he was Jewish, wanted to be treated like he was Jewish, but he really wasn't Jewish. That's fine. It goes when sincerely held religious beliefs. It's not necessarily the identification with a particular religion in that regard. It could be some modified version of it. Trust the employee. If they say they are a Pastafarianism, they'll start talking to you about spaghetti. I'm not kidding. You can ask questions about the religion if you're not sure and do research. I take the position trust unless you have reason to believe otherwise. What is a reason to believe otherwise? Well, at Easter, they're Christian. At Ramadan, there is Islam. And then at Yom Kippur, suddenly they're Jewish. That gives me pause. They're just going with the holidays in that regard. The New York State human rights law has given us clear factors that we need to look at and document in granting or denying a religious accommodation request. The workplace itself, the nature of the employee's duties, the cost associated relative to the size and budget of the employer, the effect of the accommodation on the employer's business. Are there any collective bargaining agreements or seniority systems in place? The number of people who need the accommodation, the effect on workplace safety, and whether the proposed accommodation conflicts with others' laws or may be illegal in and of itself. And let me give you a quick example of an accommodation that we granted. The individual was a Jehovah's Witness, is my recollection. Took the position, he was a truck driver. I do not want to drive a truck if I am transporting alcohol. I refuse to transport alcohol. We ran the analysis, we accommodated him. We said, no problem, we are going to not make you deliver alcohol or transport alcohol ever. About a year later, and there was no problem, he was happy, we documented. About a year later, he had a new request. This one we denied. I never want to transport a trailer that ever transported alcohol in the past. We denied it. We said, no, that's not reasonable. That creates an undue hardship. And guess what? That's our entire fleet that is transported. Every trailer has probably transported alcohol at one time or another. We denied it. We were sued. We won in that regard. Just some other considerations on the religious front to keep in mind. So if you're training your managers, take what we're giving you and go back. The law protects all aspects of the individual's religious observation and practice, even if it's not required. That's why some individuals have unique views of their religion in that regard. The employee must notify the employer of their need for the accommodation and give you time to assess it. You need to do an interactive process to work together to come up with the accommodation. The employer may ask questions about religious habits to evaluate the request and identify the accommodation. And you're not required to grant a specific accommodation request if there's something else that serves the same purposes. So the US Supreme Court has said, if an employee proposes a reasonable accommodation that would get it done, and the employer proposes another accommodation that would also serve the employee's needs, who gets to pick? It's the employer that gets to pick in that regard. That is the rule under the ADA. That is the rule under the human rights law. That is the rule under Title VII of the Civil Rights Act. What happens if we cannot exempt an individual or provide a reasonable accommodation because they don't want the vaccine based on a sincerely held religious belief? First, it's an exclusion analysis that we do, just like we do. And ultimately, we may have to grant some additional time off. And then before we terminate, no automatic terminations. It is simply, we evaluate the other leave laws in that regards. So 1 second, I'm going to turn it back to Brianna. Moral of the story, everything we just covered. If you are not compelling the vaccine, if you are not administering the vaccine, if you are not associating with a third party or contracting with a third party, wonderful, makes your life a lot easier. But if you are doing those things, what we just said is going to be your bread and butter on the slides in that regard. And if you're not compelling, if you're not doing the vaccine, and you're simply collecting the vaccine cards, keep them in the medical file and don't accept any other medical information from the employee. So with that, Brianna, let me mute myself and then I'm going to release control.
So as Mike talked about earlier, we have some interesting information about how the Genetic Information Non-Discrimination Act, which again took effect in 2009 and hasn't had a major impact on many things since that time, but now has some interesting implications when you think about the vaccine. So the question that's really come up is whether GINA is implicated when an employer administers the COVID vaccine to employees or requires the employees to provide proof that they have received the vaccination. So the answer to that is that no, administering the vaccine in and of itself to employees or requiring employees to provide proof does not implicate GINA because it does not involve the use of any genetic information to make employment decisions. So this does include vaccinations that use the messenger RNA or mRNA technology, which we'll discuss a little bit. However, the real issue that comes up with this is the pre-screening questions that may be asked before the vaccine is administered that may implicate genetic information. So under GINA, employers may not use genetic information to make employment decisions, acquire genetic information, except for in a couple very, very narrow circumstances, or disclose genetic information. And so when these vaccines first came out, this raised the question with regard to mRNA technology about whether or not the vaccines could modify a recipient's genetic makeup and therefore whether requiring an employee to get the vaccine was unlawful under GINA. Luckily, the CDC has explained that mRNA technology does not interact with our DNA in any way and does not enter the nucleus of the cell, which is where the DNA is kept. And so for any employee that may be having this kind of objection to the vaccine, we do have a link to the CDC's website here, which provides a very detailed discussion about how these vaccines do work. So because of that, whether or not the mRNA technology is used, GINA is not implicated by these vaccines. So the other question that came up is whether or not the pre-vaccination screening questions that are often asked before administering the vaccine implicates GINA. And the answer that we hinted at earlier is that these questions are likely to elicit some kind of information about disability or genetic information or information about the immune system of family members that will implicate GINA. So we don't know from the EEOC what questions are going to be asked before the vaccine is given. We do have a copy of New York State Department of Health immunization and screening questions. We have a link to that here. We've also provided them here. Now, the interesting thing that Mike hinted at earlier is that when he got the vaccine and when many other people are getting the vaccine, first of all, they're asked a variety of different questions, and many of them have nothing to do with what New York State said they were going to ask. And so these questions are included just for your information here. And again, in the appendix as well, but they may not all be asked in every circumstance, and it may vary depending on what kind of vaccine you're using. Now, under GINA, we can understand genetic information to be information about an individual or their family members' genetic tests, information about the manifestation of disease or disorder in a family member, information about genetic services of either the individual or their family member, or any information about genetic information carried in a fetus, either from the individual or family member. And so it's a pretty broad definition and includes all kinds of information that may be elicited by these pre-screening questions. But of course, if these pre-vaccination questions do not ask anything that would include that kind of information, then it does not violate GINA and there's no issue. Now, what we've sort of been starting to encourage employers to do is think about asking for proof of vaccination. So the little card that everybody's given, that everybody's seen at this point, without any supporting information. So like Mike said earlier, you don't want the information about underlying health condition or any of their answers to pre-screening questions. You really just want the card to keep in their medical file. And again, GINA is not prohibiting an individual's healthcare provider. So if they're getting it at their doctor's office, for example, the provider can ask questions that implicate genetic information. The employer just doesn't want a copy of those responses. And one of the ways that an employer can avoid that is to warn the employee not to provide any genetic information as part of the proof of the vaccination that's given by the employee. So as long as the employer warns against the employee providing any of that genetic information, then any information they do provide on accident, just as an abundance of caution, can be considered inadvertent in that case. And so we've included here model language that can be used by the employer when they're giving the employee notice that they're going to require proof of vaccination. And so what it does is it outlines what GINA does. So it prohibits an employer from requesting or requiring genetic information from an individual. And then it specifically says that to comply with GINA, you're asking that you not provide any genetic information responding to the request for medical information. And then it goes on to state the broad definition we went over earlier about what genetic information is protected under GINA. And so that will give the employer a good way to avoid coming into any contact with any GINA implications. And so that is the end of our presentation. So what I'm going to do is just turn remote control over to Mike again, and we'll address, I know, some of the questions that have come up in the chat.
Okay, so feel free to put some questions in the chat. We'll answer them as best we can. The moral of the story is be diligent. These rules are going to continue to evolve and potentially change. The vaccine law, I didn't even know was coming in the pike, and all of a sudden it is there one day. So, all right, so we have a first question here. I have an employee that was sent a DOH letter to quarantine for possible exposure. While doing his quarantine, the employee's wife got COVID, so the DOH said his quarantine would start after her quarantine date. 5 days later, his son tested positive, and our employee was told that his quarantine date would start over after the son's 10-day quarantine. Now the employee will be out almost a month and never tested positive. Would this be considered one leave, and would he only be paid for 14 days? So this is, we're starting to get these questions. I had this first overlap in that regard. If they are under a quarantine order, which it appears to be, they're clearly going to be entitled to the first round of COVID-19 leave. If they, and I'm assuming this is the general industry and not healthcare, and I'd have to go back and double check, but my recollection is that a positive COVID-19 test is required to get number 2 and 3 in that regard. Brianna, is my recollection correct?
Yeah, that's accurate.
Okay, so if the employee doesn't have that, they're not entitled to the COVID-19 leave. They would be entitled to use their paid sick leave under the New York State Paid Sick Leave Act in that regard. So just keep that in mind. It's literally, you got to run the analysis on this overlapping leave, which we're starting to see. And, I don't think it's crystal clear, but, that's what we've been doing. We just say, all right, do you have this positive test, yes or no? And if the answer is no, you're not entitled to it. But there's another part. There's another part of that guidance that I'm remembering. And Brianna, correct me if I'm wrong. If you're told to stay at home by your employer must pay you your regular wages until such time as you get a positive test. Brianna, am I remembering that part right as well?
Yeah.
Okay, so that would be something else for you to consider. The guidance that we attached from the Department of Labor for the general industries expanded greatly the scope and reach of the COVID-19 sick leave. So we would just have to make sure the facts, based on the facts, which one of those paragraphs would apply. Next question: an employee that requests a reasonable accommodation to work remotely can or cannot be denied as an undue hardship for the organization if the organization will work remotely for the entire last year. I think that is simply a factor. I don't think, like I said, there was a time we all had to work remotely. Now, what if the employee is the supervisor? The 10 people are back in the office that they supervise and they want to continue to work remotely. I'm not sure it's going to work in that regard. So just the fact alone that we've worked remotely for a year, I don't think is enough. I think there needs to be more to it, but I do think it's something in that regard. Is contact tracing required for non-medical facilities in New York? My recollection is yes, you all should be figuring out who is coming in the office on a daily basis. You should be asking your screening questions. Are you sick? Have you been exposed? Most people are either filling out a piece of paper when they come into work, or I get an email every morning at 6 o'clock on the nose. Here's your pre-screening questions for the day. Answer them. Tell us where you're going to be working, home or remote. Tell us if you're taking the day off, etc. Any other questions? Feel free to ask away. And again, sometimes you think of something in a couple days. We'll answer it. Just shoot us an email in that regard. The one thing I want you to realize, we just threw 185 slides at you. I think we had like another 12 to 20 pages of handouts. You will not know this stuff cold under any circumstance. We have to go look. Others have to go look. The HR professionals have to go look. Don't feel bad in that regard. I think it's a natural thing to answer your question properly. What we gave you today is a guide, nothing more. It is simply a guide to help you try to answer the questions, to point out to you some third-party resources like the Job Accommodation Network, and specifically the link to COVID reasonable accommodation issues. So keep all these things in mind and approach it as such. I've already mentioned, I'm pretty confident this year that recreational marijuana is going to get passed. I think we're going to see I think we're going to know this week or next week. They're going to have if they agree on a proposed bill, I think then we'll be able to come back, have another one of these webinars on the employment requirements, any drug testing requirements. How do I discipline someone in that regard for recreational use? So we'll talk about that. I think the next webinar, we will keep you informed of other updates, and we'll continue to schedule these throughout the year. So Brianna, anything you'd like to add, and then we'll turn it back over to the chamber?
I do not. Thank you.
All right, so we'll turn it back over to you, and thank you everyone for listening in. And we had pretty much all of you stayed on the entire time. So the rest of your day and hang in there. We're almost through.
Thanks, Michael and Brianna. Yes, thank you both for your presentation today. Thank you everyone for joining us. We will share the recording from today's session with everyone later on today, and you can also find it on the Chamber's COVID resource page, along with all of our previous webinars. Just one last thing I'll mention, if there's anyone who's on that's not a current Chamber member and you're interested in membership, you can contact us at 607-734-5137. Or you can shoot us an email at info@chemungchamber.org. Thank you, everyone. Have a great day.
See you, Brianna.